Welcome to the Canadian Citizen's Journal. There is a quote from a constitutional lawyer that we should all keep in mind. Question everything. In law, conclusions must be supported by evidence, not assumptions. Today, we are going to the source. I have the definitive manual on our legal system in front of me, and we are going to walk through it together. We are starting with Chapter 1. Where does our Constitution actually come from? Most people think it is just a single document from 1867 or 1982. But the truth is, the rulebook for the people in power is actually a three-part toolkit. If you only know one part, you are vulnerable. First, we have the written acts. These are the bones of the country. We have the 1867 Act that built the provinces, and the 1982 Act that gave us the Charter of Rights and Freedoms. This is the evidence we can point to in black and white. But then, there is a second part. Conventions. These are basically handshake deals. They are unwritten rules that have been followed so long, they have become mandatory. For example, did you know the written law gives the Governor General massive power, but convention says they cannot use it unless the Prime Minister tells them to? The catch is that you cannot technically sue the government for breaking a handshake deal. You can only fire them at the ballot box. Finally, there is case law. This is the muscle of the Constitution. Every time a judge makes a ruling, it adds a new rule to the book. Since this manual was printed, we have seen massive shifts. For example, the 2021 carbon tax ruling changed how we view provincial rights. The written law did not change, but the case law did, giving the federal government more power than they had 10 years ago. As we go through this journey chapter by chapter, we are going to show you how these three things, the written acts, the handshake deals, and the court rulings work together. By the time we are done, you will not have to guess what your rights are. You will have the evidence. Next time, we are diving into Chapter 2, the 1867 Act and the original blueprint of Canada. Today we are diving into Chapter 2 of the Constitutional Manual. This chapter covers the Constitution Act of 1867. This is the original blueprint for Canada. When this document was written, Canada was not a fully independent country yet. It was a collection of British colonies trying to figure out how to live together without constantly fighting. They did not write a Bill of Rights. Instead, they wrote a list of powers. The 1867 Act is what we call a federal system. This means power is split between two levels of government. The federal government in Ottawa and the provincial governments. Neither one is the boss of the other. They are supposed to be supreme in their own lanes. Section 91 lists the federal powers. These are things that affect the whole country, like the military, the postal service, and criminal law. Section 92 lists the provincial powers. These are the things that affect your daily life the most, like hospitals, schools, and what the law calls property and civil rights. Hogg explains that the reason we have so much tension in Canada today is because these two levels of government are always trying to swerve into each other's lanes. The provinces want to protect their local control, while the federal government often tries to use its spending power to tell the provinces how to run things. In 1867, the goal was to create a strong central government, but still let the provinces keep their identity. As we look at the reality of 2026, we have to ask ourselves, is that original deal still being honored? Or has the federal government moved so far out of its lane that the original blueprint is starting to crumble? Understanding Section 91 and 92 is the first step in seeing where the government is overstepping. If they do not have the power listed in the 1867 Act, they are not supposed to be doing it. It is that simple. Next time, we are moving into Chapter 3 to look at how Canada finally gained its independence from Britain. Today we are looking at Chapter 3 of our Constitutional Manual. This chapter is all about independence. Most people assume Canada became a country in 1867, and that was that. But the truth is much more complicated. In 1867, we were still a colony. Britain still controlled our foreign policy, and they could even strike down laws passed by our own parliament. Hogg explains that our independence happened in stages. The first big leap was in 1931 with something called the Statute of Westminster. This was the moment Britain officially said they would stop making laws for Canada unless we specifically asked them to. But even after 1931, we had a major problem. We did not have a way to change our own constitution. If we wanted to update the rules of the House, we still had to go to the British Parliament in London and ask them to do it for us. This brings us to 1982. This is the year of patriation. This is when the Constitution was finally brought home. Prime Minister Pierre Trudeau pushed through the Constitution Act of 1982, which finally added a formula for how Canada can change its own laws. But here is the catch that many people struggle with today. Even though we are independent, we kept the British monarch as our formal head of state. This is why you still see the king on our money, and why the government acts in the name of the crown. In Chapter 3, Hogg shows us that Canada is a country that hates sudden moves. We prefer slow, legal transitions. But as we look at the state of the country in 2026, some are asking if we ever truly finished the job of becoming independent, or if we just traded one master in London for a new set of masters in Ottawa. Understanding this history helps us see that the rules we live under today were not just handed down from heaven. They were negotiated, sometimes poorly, over 100 years. Next time, we are moving into Chapter 4 to look at the role of the courts and how judges became the final referees of our lives. Today we are looking at Chapter 4 of the Constitutional Manual. This chapter is about the courts. If the Constitution is the rulebook for the country, then the judges are the referees. Hogg explains that in our system, the courts have a special job called judicial review. This means if the government passes a law that goes outside its lane or violates the charter, the court has the power to step in and say that law is of no force or effect. Many people wonder where the courts get this power. It actually comes from Section 52 of the 1982 Act, which says the Constitution is the supreme law of Canada. Because it is the supreme law, any other law that is inconsistent with it simply does not count. Hogg breaks the court system down into a pyramid. At the bottom you have provincial courts that handle things like traffic tickets and minor crimes. Above them are the superior courts, which handle bigger trials. Then you have the Court of Appeal, for each province, but at the very top is the Supreme Court of Canada. 9 judges in Ottawa have the final word on every legal dispute in the country. Their decisions are binding on everyone, including the Prime Minister and all the premiers. The big question we face in 2026 is whether the referees are being fair. Hogg reminds us that judges are supposed to be independent from the government. They are not elected, and they cannot be fired just because the government does not like their rulings. This is supposed to protect us from a government that wants to ignore the rules. However, as we have seen with recent high-profile cases, the courts are becoming a political battlefield. When we talk about our rights, we have to remember that those rights are only as strong as the judge sitting on the bench. Next time, we are moving into Chapter 5 to look at how the executive branch works. We will look at the Prime Minister, the Cabinet, and where their power actually ends. Today we are looking at Chapter 5 of the Constitutional Manual. This chapter is about the executive branch of government. This includes the King, the Governor-General, the Prime Minister, and the Cabinet. If you read the written Constitution from 1867, it says that the executive government is vested in the Queen, or the King today. It says the Governor-General has the power to command the military and make big decisions. But as we discussed in Episode 1, unwritten rules called conventions changed all of that. Hogg explains that while the Governor-General has the legal power, they are required by convention to only act on the advice of the Prime Minister and the Cabinet. This is what we call responsible government. It means the people with the actual power must answer to the elected House of Commons. In Chapter 5, we see how the Prime Minister became the most powerful figure in the country. Even though the office of the Prime Minister is not in the original 1867 text, they control the Cabinet, they recommend who becomes a judge, and they decide when to call an election. This leads to a big question for us in 2026. If so much of our system relies on unwritten rules and handshakes, what happens when a leader decides to stop shaking hands? Hogg points out that if a government loses the confidence of the House of Commons, they are supposed to resign. That is the ultimate check on their power. However, we are seeing more and more power being centralized in the Prime Minister's office, often bypassing the regular debate in Parliament. By understanding Chapter 5, we can see where the legal authority ends and where political pressure begins. The executive branch is supposed to be the servant of the law, not the master of it. When the lines get blurred, it is the Constitution that is supposed to pull them back into place. Next time, we are moving into Chapter 6 to look at the legislative branch. We will see how laws are actually made, and why the Senate is often called the House of Sober Second Thought. Today we are looking at Chapter 6 of our Constitutional Manual. This chapter is about the legislative branch. This is the part of government that has the power to make, change, and repeal laws. In Canada, our Parliament is made of 3 parts: the King, the Senate, and the House of Commons. A law is not a law until all 3 parts have agreed to it. Hogg explains that the House of Commons is where the real political power sits, because that is where our elected representatives are. This is where most laws begin. But for a bill to become law, it has to pass 3 readings in the House, and then it goes to the Senate. The Senate is often called the House of Sober Second Thought. The senators are not elected, they are appointed. Their job is to look at the laws passed by the House and make sure they are actually good for the country in the long term. While the Senate rarely blocks a law entirely, they have the legal power to do so. The final step is something called royal assent. This is when the Governor-General signs the bill on behalf of the King. While this is mostly a formality today, it is a reminder that our system is still a constitutional monarchy. A major theme in Chapter 6 is parliamentary privilege. This is a special legal protection that allows members of parliament to speak freely in the House without being sued for libel or slandered. This is supposed to ensure that our representatives can debate the most difficult issues without fear. However, as we look at the state of debate in 2026, many people feel that Parliament has become more about performance than about creating quality laws. Hogg reminds us that the power of Parliament is not unlimited. Even if every single person in Parliament votes for a law, it can still be struck down by the courts if it goes against the Constitution. Understanding Chapter 6 helps us see that there are supposed to be checks and balances at every step of the lawmaking process. If a law feels unfair or rushed, we have to look at which part of this factory failed to do its job. Next time, we are moving into Chapter 7 to look at the different types of courts in Canada and how the judicial system is organized. Today we are looking at Chapter 7 of the Constitutional Manual. This chapter is about the courts and how they are organized. In Canada, the judicial system is built like a pyramid. At the very bottom, we have the provincial courts. These are the ones you see most often. They handle things like traffic violations, family law matters, and less serious criminal cases. These judges are appointed by the provincial government. The next level up is the Superior Court of each province. These are interesting because they are a bit of a hybrid. They are organized by the province, but the judges are appointed and paid by the federal government. These courts handle the most serious criminal trials and large civil lawsuits. Above them is the Court of Appeal for each province. This is where you go if you think a trial judge made a mistake. They do not hold new trials or listen to witnesses. Instead, they look at the record of the first trial to see if the law was followed correctly. Finally, at the very top is the Supreme Court of Canada. As we mentioned before, this is the final stop. But Chapter 7 goes deeper into a critical concept: judicial independence. Hogg explains that for our system to work, judges must be free to make decisions without fear of the government. They have security of tenure, which means they cannot be fired just because a politician dislikes a ruling. They also have financial security, meaning the government cannot lower their pay to punish them. In 2026, many people are looking at the courts and wondering if this independence is still real. Are judges being chosen based on their merit or their political leanings? Hogg reminds us that the appearance of independence is just as important as the reality. If the public loses faith that the courts are neutral, the whole constitutional structure begins to fail. Understanding the hierarchy of the courts helps us see where the battle for our rights takes place. It is not just about one judge in one courtroom. It is about a system designed to check itself at every level. Next time, we are moving into Chapter 8 to look at the legal profession itself and the role of the Attorney General. Today we are looking at Chapter 8 of our Constitutional Manual. This chapter covers the legal profession and a very important office called the Attorney General. In Canada, the legal profession is self-governing. This means that lawyers are not regulated by the government, but by their own law societies. Hogg explains that this is a constitutional necessity. If the government controlled the lawyers, it would be very difficult for a citizen to find a lawyer willing to sue the government. Independent lawyers are a shield for the public. But the most complex role in this chapter is the Attorney General. This person is usually the Minister of Justice, which means they sit in the cabinet with the Prime Minister. However, as the Attorney General, they have a special duty to the court and the public that sits above their loyalty to their political party. Hogg explains that the Attorney General is the one who decides whether to prosecute a crime or whether to settle a lawsuit against the government. By convention, the Prime Minister is not supposed to tell the Attorney General how to do their job regarding specific legal cases. We have seen major scandals in recent years where this line was blurred. When a Prime Minister or a cabinet puts pressure on the Attorney General to drop a case or change a legal opinion, it threatens the very foundation of our justice system. Chapter 8 also touches on the right to legal counsel. While the Charter says you have the right to a lawyer if you are arrested, it does not necessarily mean the government has to pay for one in every situation. This creates a massive gap in our system, where many citizens are left to defend their constitutional rights alone because they cannot afford the high cost of the legal profession. Understanding Chapter 8 helps us see that the law is not just a set of rules. It is a profession guarded by people. Whether those people act as gatekeepers for the powerful or protectors of the public depends entirely on how well we hold them to their constitutional duties. Next time, we are moving into Chapter 9 to look at the different levels of government and how they share or fight over tax dollars. Today we are looking at Chapter 9 of our Constitutional Manual. This chapter is all about money. Specifically, who has the right to tax you and how that money is spent. The 1867 Act gave the federal government the power to raise money by any mode or system of taxation. This is a massive power. The provinces, on the other hand, were originally limited to what is called direct taxation within the province. Hogg explains that because the federal government has a much easier time raising large amounts of money, we have what is called a vertical fiscal imbalance. This means the federal government often has more money than it needs for its specific jobs, while the provinces have more jobs than they have money. This imbalance created the spending power. This is a controversial concept because it is not explicitly written in the Constitution. It is the idea that the federal government can spend its money on anything it wants, even on things that are technically in the provincial lane, like healthcare or housing. In 2026, we see this play out every day. The federal government offers billions of dollars to the provinces, but only if the provinces agree to follow federal rules. This is how the federal government exerts control over areas where they legally have no authority to pass laws. Chapter 9 also covers Section 125, which says that the government cannot tax the government. For example, the province cannot tax federal land, and the federal government cannot tax provincial property. This was meant to keep the two levels of government independent of each other. However, as the federal government uses its financial weight to push its agenda, many are asking if the provinces have become mere branch offices of Ottawa. Hogg reminds us that a province can always say no to federal money, but in reality, the political pressure to take the cash is often too high to resist. Understanding Chapter 9 helps us see that the battle for the Constitution is often fought in the budget office, not just the courtroom. When you follow the money, you find the real seat of power. Next time, we are moving into Chapter 10 to look at the rules of the House regarding the amendment formula, how we actually change the Constitution. Today we are looking at Chapter 10 of our Constitutional Manual. This chapter is about how we change the Constitution, which is known as the amendment formula. For the first 115 years of Canada's history, we did not have a way to change our own supreme law. We had to ask the British Parliament to do it for us. That finally changed in 1982. But the leaders at the time were so worried about one province, or the federal government having too much power, that they made the new rules incredibly complicated. Hogg explains that there is not just one way to change the Constitution. There are actually 5 different formulas, depending on what you want to change. The most famous one is the general formula, often called the 7 and 50 rule. To change most things, you need the federal parliament plus the legislatures of at least 7 provinces that represent at least 50% of the total population. This is why it is so hard to get anything done. If Ontario and Quebec disagree, or if several smaller provinces band together, the change is dead. Then there is the unanimity rule. For the really big things, like the role of the king, the composition of the Supreme Court, or the English and French language rights, every single province and the federal government must agree. One province saying no can stop the entire country. Hogg notes that since these rules were put in place in 1982, we have had several major attempts to change the Constitution, such as the Meech Lake Accord and the Charlottetown Accord. Both failed. Because it is so hard to change the written text, the government often tries to find workarounds, or the courts change the meaning of the rules through their rulings instead. In 2026, many people are frustrated with the system. They want to reform the Senate, or change how elections work, or clarify provincial rights. But Chapter 10 shows us that the door to change is locked with multiple keys, and those keys are held by different politicians who rarely agree. Understanding the amendment formula helps us see why Canada is such a stable country, but also why it is so resistant to reform. The rules were written to make sure that no one person can reinvent the country overnight. Next time, we are moving into Chapter 11 to look at the role of the Crown and the Governor General in more detail. Today we are looking at Chapter 11 of the Constitutional Manual. This chapter is about the Crown. Canada is a constitutional monarchy. This means that while we are a democracy, the formal head of our state is the King. Because the King does not live here, his powers are exercised by the Governor General at the federal level and by lieutenant governors in each province. Hogg explains that the Crown has 2 types of powers. The first are statutory powers, which are given by laws passed in Parliament. The second are prerogative powers, which are ancient powers that belong to the monarchy by tradition. Most of the time, the Governor General acts only on the advice of the Prime Minister. This is the convention we have discussed before. But Chapter 11 dives into a very important and rare area called reserve powers. These are powers the Governor General can use without advice, or even against the advice of the Prime Minister. For example, if a Prime Minister refused to resign after losing an election, or tried to do something clearly illegal, the Governor General has the constitutional authority to fire them. This makes the Governor General the ultimate guardian of the Constitution. In 2026, people often ask, why do we still have this system? Hogg points out that by having a head of state who is non-political and stays out of daily government business, we ensure that the military and the police owe their loyalty to the law and the Crown, not to a specific political party. However, because these reserve powers are so rarely used, Many wonder if a governor general would actually have the courage to step in during a real crisis. As we have seen in recent history, the line between being a figurehead and being a protector is very thin. Understanding Chapter 11 helps us see that our system was designed with an emergency brake. Whether that brake still works is something we must constantly watch. Next time, we are moving into Chapter 12 to look at the different levels of government again, but this time focusing on the concept of federalism. Today we are looking at Chapter 12 of our constitutional manual. This chapter is about federalism. Federalism is the soul of the Canadian Constitution. It is the idea that power is divided between the federal government and the provinces, so that each is sovereign in its own area. Neither level of government is the employee of the other. They are co-equals under the law. Hogg explains that the reason we chose federalism back in 1867 was to protect diversity. The people who built this country knew that a central government in one city could not possibly understand the local needs, languages, and cultures of every region. Federalism was the solution to keep the country together while letting the provinces stay unique. However, federalism creates a constant tension. Hogg describes three main characteristics of a federal system. First, the division of powers must be written in a constitution that is hard to change. Second, there must be an independent referee, which is the court system. And third, there must be a way to settle disputes when both levels of government try to pass laws on the same subject. One of the most important rules Hogg covers in this chapter is the doctrine of paramountcy. This rule says that if a federal law and a provincial law are both valid but they contradict each other so much that you cannot obey both, the federal law wins. But the courts only use this as a last resort. They prefer to let both laws exist whenever possible. In 2026, we are seeing the federal government use its powers to push deep into provincial territory, often using the excuse of national emergencies or national concerns. By understanding Chapter 12, we can see that federalism is a shield. It is meant to prevent any one government from having total control over every aspect of a citizen's life. When federalism is working, it creates a balance of power. When it fails, we end up with a system where the provinces are treated like children of the federal government, which is exactly what the Constitution was designed to prevent. Next time, we are moving into Chapter 13 to look at the Peace, Order, and Good Government Clause. This is the emergency button of the Constitution. Today we are looking at Chapter 17 of our constitutional manual. This chapter is about a power called Peace, Order, and Good Government, or POG for short. In Section 91 of the 1867 Act, it says the federal government can make laws for the peace, order, and good government of Canada in relation to all matters not assigned exclusively to the provinces. Hogg explains that this was intended to be a gap filler. If a new issue came up that the writers of 1867 did not think of, the federal government would handle it. Over time, the courts have broken the POG power into three specific branches. The first is the gap branch. This covers things that were simply left off the list, like incorporated companies or new technologies that did not exist in 1867. The second is the national concern branch. This is where things get controversial. If a problem becomes so big that it affects the entire country, and a province cannot handle it alone, the federal government can claim jurisdiction over it. Hogg notes that once something is declared a national concern, the federal government gains permanent power over that subject. We saw this play out in the 2021 Supreme Court decision on the carbon tax, where the court used this branch to allow a federal tax on a provincial subject. The third is the emergency branch. This is the most powerful. In a time of war, famine, or insurrection, the federal government can use POG to pass almost any law, even if it invades provincial territory. However, unlike the national concern branch, this power is only temporary. Once the emergency is over, the federal government is supposed to give that power back to the provinces. In 2026, many citizens are concerned about the permanent emergency mindset. By understanding Chapter 17, we can see that POG was never meant to be a blank check for the federal government. It was designed to be a specific tool for specific problems. The struggle today is defining what counts as a national concern. If everything is a national concern, then provincial rights disappear. Hogg reminds us that the courts are the only ones who can decide where that line is drawn. Next time, we are moving into Chapter 18 to look at one of the most frequently used federal powers, criminal law. Today we are looking at Chapter 18 of our constitutional manual. This is one of the most powerful tools in the federal toolkit, the criminal law power. Under the original 1867 blueprint, the federal government was given the exclusive right to define what is a crime and how it should be punished. This was done so that a crime in New Brunswick would be a crime in British Columbia. We have one criminal code for the whole country. But Hogg explains that the courts have given this power a very wide lane. For a law to be a valid criminal law, it generally just needs a prohibition, meaning don't do this, and a penalty, meaning if you do it, here is the fine or jail time. Because the goal of criminal law is to protect public peace, order, security, health, or morality, the federal government often uses this power to jump into areas that usually belong to the provinces. For example, the federal government uses the criminal law power to regulate drugs, tobacco, and even certain environmental pollutants. They aren't just managing these things, they are saying that if you don't follow their rules, you are a criminal. However, there is a limit. Hogg points out that the federal government cannot use the criminal law power just as a pretense to take over provincial jobs. They can't just slap a fine on something and call it a crime if the real goal is to manage a local business or a provincial school. In 2026, we have to look closely at new federal mandates. Are they truly about public safety, or is the criminal law power being used as a sword to bypass the provinces and control the behavior of individual citizens? Understanding Chapter 18 reminds us that while the federal government has the sword, the Constitution provides the shield. If a law doesn't have a legitimate public purpose, it might not be a valid criminal law at all. Next time, we are diving into Chapter 19 to look at the power over taxes and finance. We've talked about spending, but now we'll look at how they legally take it from you in the first place. Today we are looking at Chapter 19 of the Constitutional Manual. This is a chapter everyone feels in their wallet: the power to tax. The writers of the 1867 Act were very clear about one thing. They wanted the federal government to be financially strong. That is why Section 91 gives Ottawa the power to tax you in any way they see fit. Income tax, sales tax, excise tax. If they can dream it up, they can legally implement it. The provinces, however, were given a much shorter leash. They are limited to what is called direct taxation. Hogg explains that a direct tax is one that is demanded from the very person who is intended to pay it, like your personal income tax. An indirect tax is something like a customs duty, where a merchant pays the tax and then hides the cost in the price of the goods you buy. For a long time, this was a major hurdle for provinces. But over the last century, the courts have expanded the definition of direct tax, so much that provinces can now tax almost anything, as long as they word the law correctly. One of the most important takeaways from Chapter 19 is that there is no constitutional rule against double taxation. Both the federal government and your provincial government can tax the exact same dollar you earn. There is no limit to how much they can take, as long as the tax is legally passed by Parliament or the legislature. Hogg also points out that a tax cannot be used as a penalty to control behavior, unless it follows the rules of the criminal law power we discussed in the last episode. If a tax is actually a fine in disguise, it can be challenged in court. In 2026, we see the tax power being used not just to run the government, but to push social and environmental agendas. By understanding Chapter 19, we can see that the power to tax is the power to steer the country. If you control the gold, you make the rules. Next time, we are moving into Chapter 20 to look at the power over trade and commerce. This is the battleground for pipelines, interprovincial trade, and national business standards. Today we are looking at Chapter 20 of the Constitutional Manual. This is the trade and commerce power. On paper, this sounds like the federal government should be in charge of the whole economy, but the courts have been very careful to keep this power from swallowing up provincial rights. Hogg explains that the trade and commerce power is split into two distinct branches. The first is international and interprovincial trade. This is the clear lane for the federal government. If a business deal crosses a border, whether it's to another province or another country, Ottawa is the boss. They control the pipelines, the railways, and the big picture rules for moving goods. The second branch is called the general trade and commerce power. This is much trickier. It allows the federal government to regulate the economy as a whole, but only if the issue is truly national in scope. For example, they can create national laws for competition or trademarks, but they generally cannot tell a local corner store how to run its business. Hogg points out that the provinces have a very strong shield here: property and civil rights. This power gives provinces the right to regulate almost every business contract within their own borders. This is why we have different labor laws, different insurance rules, and even different professional standards from one province to another. In 2026, the big fight is over whether the federal government can use the trade and commerce power to force national standards on things like the green economy or digital privacy. Understanding Chapter 20 helps us see that Canada was never meant to be a single, uniform market controlled from the top down. It was designed to be a collection of local markets that work together. When the federal government tries to micromanage local trade, they aren't just overreaching, they are shaking the foundation of the 1867 deal. Next time, we are moving into Chapter 21 to look at a power that has become a major topic of conversation lately: natural resources. Today we are looking at Chapter 21 of the Constitutional Manual. This is the chapter on natural resources. When Canada was formed in 1867, the provinces were given ownership of the public lands and the resources within them. This is found in Section 109. This means that whether it is oil in Alberta, hydropower in Quebec, or timber in New Brunswick, the province is the landlord. Hogg explains that this ownership gives provinces massive leverage. They can decide who gets to drill, how much they pay in royalties, and how the resources are managed. In 1982, we even added Section 92A to the Constitution, which was a resource amendment, specifically designed to strengthen provincial control over non-renewable resources and forestry. But here is where the conflict starts. Even though the province owns the oil in the ground, the federal government controls the pipes that take it out of the province. They also control international trade, and, as we discussed in a previous episode, they have the power over criminal law and Hogg to protect the environment. Hogg points out that the federal government can use its powers to make it almost impossible for a province to develop its resources, even though Ottawa doesn't own them. This creates a legal stalemate. The province says it's my land, and the federal government says it's my border and my environment. In 2026, this is arguably the most heated constitutional battle in the country. Are the provinces still truly sovereign over their own wealth? Or has the federal government used environmental law as a backdoor to seize control of the provincial economy? Understanding Chapter 21 helps us see that the resource wars in Canada aren't just about politics. They are about two different levels of government, both claiming they have the final word over the same piece of land. Next time, we are moving into Chapter 22 to look at the power over transportation and communication. This covers everything from the CBC to the internet and our highways. Today we are looking at Chapter 22 of the Constitutional Manual. This chapter covers transportation and communication. The writers of the 1867 Act knew that for Canada to survive, it had to be physically connected. That is why Section 92 gives provinces control over local works and undertakings, but Section 91 says that if a work connects provinces or extends beyond a province, it belongs to the federal government. This is why your provincial government handles the highway in your town, but the federal government handles the railways and the airlines. If it crosses a border, Ottawa is the boss. But the most interesting part of this chapter is about communication. Because radio, television, and the internet did not exist in 1867, the courts had to decide where they fit. Using the Hogg power we discussed earlier, the courts decided that because airwaves and digital signals don't stop at provincial borders, they must be under federal control. Hogg explains that this gives the federal government the power to create the CBC, regulate private broadcasters, and, most importantly in 2026, regulate the internet and social media platforms. However, there is a limit. While the federal government can regulate the signal or the content, they cannot necessarily regulate the business of a local company just because it uses a phone or a computer. This creates a complex overlap where a company might have to follow provincial labor laws but federal communication laws. In 2026, the big question is how far the federal government can go in managing the digital square. If the internet is a national communication system, does that give Ottawa the right to decide what is harmful or misleading? Chapter 22 shows us that while the federal government has the power to manage the system, that power is supposed to be about technical connectivity, not necessarily controlling the thoughts and speech of the people using it. Understanding this chapter helps us see that the cables and signals that connect us are legally different from the ground we walk on. Next time, we are moving into Chapter 23 to look at the power over banking and insolvency. We will look at how the government controls the money supply and what happens when people or businesses go broke. Today we are looking at Chapter 23 of the Constitutional Manual. This chapter is about banking and insolvency, or in plain English, who controls the money and what happens when it runs out. The writers of the 1867 Act wanted a single, stable financial system. They didn't want each province printing its own money or having its own banking rules. That is why Section 91 gives the federal government exclusive power over currency and coinage and banking. Hogg explains that this power is very broad. It covers everything from how a bank is created to how it must behave. This is why our big banks are federally regulated. Even if a bank only has branches in one province, it still follows Ottawa's rules. The second half of this chapter is about insolvency and bankruptcy. If you or a business can no longer pay your debts, you enter a legal process that is governed by federal law. The goal is to make sure that creditors are treated fairly and that people can eventually get a fresh start. Hogg points out a very important overlap here. While the federal government controls banking, the provinces control property and civil rights. This means that while Ottawa regulates the bank, the province regulates the contract you sign for a car loan or a payday loan from a non-bank lender. In 2026, we are seeing a lot of friction in this area. With the rise of digital fintech apps and new types of lending, there is a constant debate over whether these new companies are banks, which Ottawa controls, or just credit businesses, which the provinces control. Understanding Chapter 23 helps us see that the federal government is the ultimate architect of our debt system. They control the interest rates through the Bank of Canada, and they set the rules for when the debt becomes too much to handle. Next time, we are moving into Chapter 24 to look at marriage and divorce. This is one of the most personal areas where the federal government and the provinces have to share power. Today we are looking at Chapter 24 of our constitutional manual. This chapter is about marriage and divorce. When the 1867 blueprint was written, the authors decided to split the power over the family into two parts. They gave the federal government the power over the status of marriage. This means Ottawa decides the legal requirements for who is allowed to marry whom. This is why the laws regarding same-sex marriage or the minimum age for marriage are the same from coast to coast. However, the provinces were given the power over the solemnization of marriage. This means your provincial government decides the rules for the actual ceremony. Things like who can officiate the wedding, where it can happen, and the paperwork required for a marriage license. Hogg explains that the federal government also has exclusive power over divorce. This is why we have a Federal Divorce Act. It ensures that if you get a divorce in New Brunswick, it is legally recognized in British Columbia. But here is where it gets complicated for many families. While the federal government handles the divorce itself, the provinces handle property and civil rights. This means that the rules for how you split your house, your car, and your savings are usually determined by provincial law, not federal law. In 2026, we see a lot of debate around how these laws apply to common law relationships. Because common law couples aren't technically married under the federal definition, they fall almost entirely under provincial rules. This creates a patchwork of rights, depending on which province you live in. Understanding Chapter 24 helps us see that even in our personal lives, the Constitution is always present. The state divides the family into status and ceremony, and knowing which government is in charge of which part is essential for protecting your rights. Next time, we are moving into Chapter 25 to look at criminal procedure. We've talked about what a crime is, but next we look at the rules the police and the courts must follow when they come after you. Today we are looking at Chapter 25 of the Constitutional Manual. This chapter is about criminal procedure. While the federal government defines what a crime is, they also set the rules for how that crime is investigated and prosecuted. This is a federal power under Section 91(27). It ensures that your rights during a trial are the same, whether you are in St. John or Vancouver. Hogg explains that criminal procedure is the balancing act between the power of the state to enforce laws and the right of the individual to be treated fairly. This includes the rules for search warrants, the right to remain silent, and the rules of evidence, which decide what a judge is allowed to hear and what must be kept out of the courtroom. One of the most important concepts in this chapter is the presumption of innocence. Hogg emphasizes that the procedure is designed to put the burden of proof entirely on the government. You do not have to prove you are innocent. The state must prove you are guilty beyond a reasonable doubt. However, there is a catch. While the federal government makes the procedural rules, the provinces are responsible for the administration of justice. This means the province pays for the courthouses, hires the crown prosecutors, and manages the police forces. This split can sometimes lead to justice by geography, where a case might move faster or slower depending on how well a province funds its system. In 2026, we are seeing a major shift in how digital evidence is handled. Can the police search your phone without a warrant? Can they use artificial intelligence to predict crimes? Chapter 25 shows us that while technology changes, the constitutional requirement for due process does not. Understanding this chapter helps us see that the law is not just a hammer, it is a system with strict boundaries. If the police or the prosecutors step outside those boundaries, the Constitution acts as a shield to stop them. Next time, we are moving into Chapter 26 to look at Aboriginal peoples. This is a deeply complex area of the law that deals with treaties, land rights, and the unique relationship between Indigenous nations and the Crown. Today we are looking at Chapter 28 of the Constitutional Manual. This chapter is about Aboriginal peoples and the law. In the original 1867 blueprint, the federal government was given exclusive power over Indigenous people and their lands. This was intended to ensure that there was a consistent national policy, rather than a patchwork of different rules in every province. However, as Hogg explains, this area of law changed forever in 1982. Section 35 was added to the Constitution. This section is unique because it is not part of the Charter of Rights and Freedoms. It stands on its own. It recognizes and protects the rights that Indigenous groups already held through treaties or through their historical use of the land. One of the most important concepts Hogg covers is the fiduciary duty. This is a legal term that means the Crown, the government, has a special obligation to act in the best interest of Indigenous peoples when dealing with their land or their rights. The government cannot just act like a cold bureaucracy, it must act with honor. This creates a massive legal requirement called the duty to consult. Whenever the government wants to do something that might affect indigenous rights, like building a pipeline, a mine, or a highway, they have a constitutional duty to talk to the affected groups and accommodate their concerns. In 2026, we see this play out in almost every major resource project in the country. Many people find the legal landscape confusing, but Hogg reminds us that these rights are not gifts from the government. They are legal obligations that the government agreed to when they signed treaties or took over the administration of the land. Understanding Chapter 28 helps us see that Canada is built on a series of foundations. There are the provincial rights, the federal rights, and the inherent rights of the people who were here first. When the government fails to respect any of these, the entire structure of the law is weakened. Next time, we are moving into Chapter 33. We are finally entering the most famous part of our supreme law, the Charter of Rights and Freedoms. This is where we look at your personal liberties. Today we are entering a new section of our constitutional manual. We are looking at Chapter 33, which introduces the Canadian Charter of Rights and Freedoms. Before 1982, if you thought a law was unfair, you usually had to prove that the wrong level of government passed it. For example, that the feds were doing a province's job. But after the charter was signed, the focus shifted to the individual. Now, even if a law is passed by the correct level of government, it can be struck down if it violates your fundamental rights. Hogg explains that the charter applies to all levels of government, federal, provincial, and municipal. It also applies to anybody that is controlled by the government, like the police or public health authorities. However, it does not apply to private disputes between individuals or private companies. If your employer at a private shop treats you unfairly, that is a labor law issue, not a charter issue. One of the most important things Hogg points out is that the charter changed the role of our judges. Before 1982, judges were mostly referees between Ottawa and the provinces. Today, they are the guardians of our liberty. They have the power to tell the Prime Minister or a Premier that their law is unconstitutional and therefore of no force or effect. But the Charter is not a list of absolute permissions. Every right in the Charter is subject to Section 1, which we will look at in our next episode. Section 1 says that rights can be limited if the government can demonstrably justify it in a free and democratic society. In 2026, the Charter is the most powerful tool a citizen has. It protects your right to speak, your right to gather, and your right to be free from arbitrary state power. But a shield only works if you know how to hold it. Next time, we are diving into Chapter 35 to look at Section 1 and Section 33. These are the limitations and the overrides, the fine print that tells us when the government is allowed to ignore your rights. Today we are looking at Chapter 35 of the Constitutional Manual. This is a heavy chapter because it deals with the limits on your rights, specifically Section 1 and Section 33 of the Charter. Section 1 is the very first sentence of the Charter. It says that your rights are guaranteed, but they are subject to reasonable limits that can be demonstrably justified in a free and democratic society. Hogg explains that this created what we call the Oakes test. If the government wants to limit your right, for example, your right to protest or your right to travel, they have to prove 4 things in court. First, the goal must be very important. Second, the limit must actually work to achieve that goal. Third, the government must interfere with your rights as little as possible. And fourth, the harm done to your rights must not be worse than the benefit to society. But then there is Section 33, better known as the Notwithstanding Clause. This is the emergency brake for the politicians. It allows Parliament or a provincial legislature to pass a law that intentionally violates your fundamental freedoms, your legal rights, or your equality rights. As long as the government explicitly says they are using Section 33, the courts cannot strike the law down. However, there is a catch. The override only lasts for 5 years. After that, the government has to renew it, which usually means they have to face the voters in an election and justify why they are still suspending your rights. Hogg notes that the authors of the Constitution included these clauses as a safety valve to ensure that the elected government, and not just the judges, would have the final say on major social issues. In 2026, we are seeing a tug of war. Governments are using Section 1 to justify emergency measures, and some provinces are using Section 33 to push through laws without court interference. Understanding Chapter 35 helps us see that the Charter is a living document. It's a constant argument between the power of the state and the freedom of the individual. Next time, we are moving into Chapter 37 to look at fundamental freedoms. This includes your right to religion, expression, and assembly. Today we are looking at Chapter 37 of the Constitutional Manual. This is the big one. It covers Section 2 of the Charter, which lists our 4 fundamental freedoms. First is freedom of conscience and religion. This doesn't just protect your right to go to a church, a mosque, or a temple. It protects your right to hold any deeply held moral or spiritual belief. Hogg explains that the government cannot force you to act against your conscience. and they cannot favor one religion over another. Second is freedom of thought, belief, opinion, and expression. This includes freedom of the press and other media. This is the freedom that allows the Canadian Citizens Journal to exist. It is a very broad right. Even expression that is unpopular, offensive, or controversial is protected, because the courts have decided that a marketplace of ideas is better than government censorship. Third and fourth are the freedoms of peaceful assembly and association. These are your rights to gather in groups, whether for a protest, a political party, or a union. These freedoms ensure that citizens can work together to influence the government and hold it accountable. Hogg points out that while these freedoms are fundamental, they are not absolute. As we discussed in the last episode, they can be limited by Section 1, but only if the government can prove it is absolutely necessary. For example, your freedom of expression does not protect you if you are inciting immediate violence, and your freedom of assembly must be peaceful. In 2026, the battle for these freedoms is moving online. We are seeing laws that try to regulate what can be said on social media and how groups can organize on the web. By understanding Chapter 37, we can see that these digital spaces are the new town squares. The same constitutional protections that apply to a speaker on a soapbox apply to a citizen on a smartphone. Next time, we are moving into Chapter 38 to look at democratic rights. This covers your right to vote and the requirement that the government must face the people in an election at least every 5 years. Today we are looking at Chapter 38 of the Constitutional Manual. This is the chapter on democratic rights. In many parts of the world, voting is a privilege that can be taken away. But in Canada, Section 3 of the Charter makes it a constitutional right for every citizen to vote in an election and to be eligible to serve as a member of parliament or a provincial legislature. Hogg explains that this right is absolute, in a way many others aren't. While the government can use Section 1 to limit your speech, it is much harder for them to legally justify stopping a citizen from voting. Another critical piece of this chapter is the 5-year rule, found in Section 4. This is the constitutional expiration date for any government. No House of Commons and no provincial legislative assembly can continue for longer than 5 years. This ensures that the people always have a scheduled opportunity to fire their representatives. The only exception is in a time of real or anticipated war, invasion, or insurrection. And even then, 2/3 of the members must agree to the delay. Section 5 also requires that Parliament and the legislatures must sit at least once every 12 months. This prevents a government from ghosting the public. They can't just take your tax money and refuse to show up for work or face questioning from the opposition. In 2026, we see a lot of talk about how elections are run and who gets to participate. Understanding Chapter 38 helps us see that these aren't just political traditions, they are the legal requirements that keep the government accountable. The ballot box is the ultimate check and balance in the Canadian system. Next time, we are moving into Chapter 39 to look at mobility rights. This covers your right to move between provinces and your right to enter or leave the country. Today we are looking at Chapter 39 of the Constitutional Manual. This chapter covers mobility rights, the laws that ensure you aren't a prisoner of your own province. Under Section 6 of the Charter, every citizen of Canada has the right to enter, remain in, and leave the country. This is a powerful protection. It means the government cannot exile you or prevent you from coming home to your own country. But Section 6 also covers what happens inside our borders. It says that every citizen and every permanent resident has the right to move to and take up residence in any province. It also gives you the right to pursue a livelihood, meaning to work in any province. Hogg explains that this was put in place to prevent provinces from creating protectionist rules, like only hiring people who were born in that province. Canada is meant to be an open market for labor. However, as we've seen in recent years, there are exceptions. Hogg points out that provinces can still have, quote, reasonable residency requirements for things like social services or healthcare. You can't just drive into a new province and claim their specific benefits on day one. There is also a specific affirmative action clause. If a province has a higher than average unemployment rate, they are allowed to create programs that favor their own residents to help them find work, even if it technically limits the mobility of people from other provinces. In 2026, mobility rights have become a major talking point. We've seen what happens when provinces try to close their borders for public health or safety reasons. Chapter 39 teaches us that while the government can try to limit your movement under Section 1, which we discussed earlier, your right to live and work anywhere in this country is a fundamental pillar of being Canadian. Next time, we are moving into Chapter 40 to look at legal rights. This is the section that protects you from unreasonable search and seizure. If you've ever wondered about your privacy and the police, you won't want to miss this one. Today we are looking at Chapter 40 of the Constitutional Manual. This is a vital chapter for anyone concerned about privacy and government overreach. It covers Section 8 of the Charter, the right to be secure against unreasonable search or seizure. Hogg explains that the core of this right is your reasonable expectation of privacy. This means that in places where you expect to be left alone, like your home, your car, or your personal computer, the government needs a very good reason to intrude. Usually, that good reason must be backed up by a warrant. A warrant is a piece of paper signed by a judge that gives the police permission to search a specific place for specific things. To get one, the police have to show prior authorization. They have to prove to the judge that they have reasonable and probable grounds to believe a crime has been committed. But Hogg points out that there are exceptions. In exigent circumstances, like if someone is in immediate danger or if evidence is about to be destroyed, the police can sometimes act without a warrant. However, the courts look at these exceptions very closely to make sure they aren't being abused. In 2026, the biggest battleground for Section 8 is informational privacy. Your smartphone contains more personal information than a filing cabinet ever could. The courts have ruled that because we have a high expectation of privacy in our digital lives, the police generally cannot just scroll through your texts or emails during a routine stop without a specific warrant for that device. Understanding Chapter 40 reminds us that the state does not have an all-access pass to your life. Whether it's physical property or digital data, the Constitution requires the government to knock before they enter. If they don't follow the rules, any evidence they find might be thrown out of court. Next time, we are moving into Chapter 41 to look at detention and arrest. We'll look at what your rights are the moment the police tell you that you aren't free to leave. Today we are looking at Chapter 41 of the Constitutional Manual. This is a chapter everyone should know by heart, because it deals with the exact moment the government restricts your physical liberty, detention and arrest. Section 9 of the Charter says you have the right not to be arbitrarily detained. This means the police can't just stop you on a whim or for no reason at all. Hogg explains that for a detention to be legal, there must be reasonable suspicion that you are connected to a particular crime. But what if they do stop you? That's where Section 10 kicks in. The moment you are detained or arrested, the state has 3 immediate duties. First, they must tell you the reason why. You have the right to be informed promptly of the chose or the reason for your detention. Second, they must tell you that you have the right to retain and instruct legal counsel. In plain English, you have the right to a lawyer. And third, they have to give you that opportunity without delay. This doesn't just mean they tell you that you have a right to a lawyer, it means they have to stop questioning you and give you a private phone and a directory to actually call one. Hogg points out an important detail. A detention doesn't just happen when you are in handcuffs. It happens whenever a person feels they have no choice but to comply with a police officer's direction. If you feel you aren't free to walk away, you are likely detained, and your Section 10 rights should be active. In 2026, we see many gray areas with roadside stops and regulatory checks. Understanding Chapter 41 helps you recognize the line between a voluntary conversation and a legal detention. The Constitution ensures that the moment the state stops you, the clock starts ticking on your rights. Next time, we are moving into Chapter 42 to look at the right to counsel. We'll go deeper into exactly how the government must help you get legal advice when you are in trouble. Today we are looking at Chapter 42 of the Constitutional Manual. This chapter is a deep dive into Section 10b, your right to retain and instruct a lawyer without delay. Hogg explains that this right isn't just a suggestion. It imposes 2 very specific duties on the police. First is the informational duty. It's not enough for an officer to mumble that you have a right to a lawyer. They must explain it clearly, tell you about the existence of legal aid or duty counsel, lawyers who are available for free or at a low cost, and ensure you actually understand what they are saying. Second is the implementational duty. Once you say, "I want to call a lawyer," the police must give you a reasonable opportunity to do so. They have to provide a telephone and a private space. More importantly, they must hold off on trying to get a statement or evidence from you until you've had a chance to get legal advice. Hogg points out that this right is a safety valve for the right to remain silent. If you don't know your legal position, you might accidentally say something that the state will use against you later. The lawyer is there to level the playing field between a single citizen and the massive power of the government. In 2026, we see many cases where people feel pressured to just cooperate and skip calling a lawyer. Chapter 42 reminds us that the Constitution assumes you need legal help when the state is investigating you. It is a fundamental part of a fair system. You aren't looking guilty by asking for a lawyer. You are simply using the shield the law provided for you. Next time, we are moving into Chapter 43 to look at trial rights. This includes the right to be tried within a reasonable time and the right to be presumed innocent until proven guilty. Today we are looking at Chapter 43 of the Constitutional Manual. This chapter covers your trial rights under Section 11 of the Charter. Section 11 is a long list of protections designed to make sure the government can't just throw you in a room and forget about you. One of the most important parts is Section 11b, the right to be tried within a reasonable time. Hogg explains that the courts have set strict limits on this. For most cases, the government has about 18 to 30 months to get you from the day you are charged to the end of your trial. If they take longer than that without a very good reason, the judge can stay the charges, which means the trial is over and you go free. This forces the government to fund the courts and keep the system moving. Then there is Section 11d, the presumption of innocence. This is the bedrock of our liberty. It means the burden of proof is always on the Crown. You don't have to prove you did nothing wrong. The state must prove you are guilty, beyond a reasonable doubt. If there is a reasonable doubt in the judge's mind, you must be acquitted. Hogg also highlights Section 11g, which says you cannot be found guilty for something that wasn't a crime at the time you did it. The government cannot pass a law today and arrest you for what you did yesterday. The rules must be known and clear before the state can punish you. In 2026, our court systems are under immense pressure, and many cases are being stayed because they are taking too long. Understanding Chapter 43 helps us see that these rules aren't technicalities. They are protections that ensure the government cannot use the legal system as a tool of endless harassment. Next time, we are moving into Chapter 44 to look at self-incrimination. This is your right to remain silent and your right not to be a witness against yourself. Today, we are looking at Chapter 44 of the Constitutional Manual. This is a vital lesson on the right against self-incrimination. In Canada, the principle is simple. The state must prove its case without your help. Section 11c of the Charter says that if you are charged with an offense, you cannot be compelled, meaning forced, to be a witness in the proceedings against yourself. You have the absolute right to sit in that courtroom and say nothing at all, and the judge is not allowed to assume you are guilty just because you didn't testify. Hogg explains that this is supported by Section 13, which provides a form of use immunity. This means that if you testify in any legal proceeding, maybe as a witness in someone else's trial, the evidence you give cannot be used to incriminate you in a later case. The only exception is if you lie under oath, which is called perjury. The goal here is to encourage people to tell the truth in court, without the fear that their own words will be recycled by the government to put them in jail later. Hogg also points out that while this right is strong, it is individual. It protects people, not corporations. A company cannot claim a right to silence to avoid handing over business records that might show a crime was committed. In 2026, we see a lot of pressure on individuals to confess or explain themselves in the court of public opinion. But Chapter 44 reminds us that in the court of law, silence is a protected constitutional right. The government has the burden of proof, and you have the right to remain silent while they try to meet it. Next time, we are moving into Chapter 45 to look at cruel and unusual punishment. We'll look at Section 12 and the limits on how the state is allowed to treat prisoners and those who have been convicted. Today we are looking at Chapter 45 of the Constitutional Manual. This chapter covers Section 12 of the Charter, the right not to be subjected to any cruel and unusual treatment or punishment. Hogg explains that this protection applies to everyone in Canada, whether they have been convicted of a crime or are simply being held by the state. The courts use a specific test for this. They ask if the punishment is grossly disproportionate. This means that the punishment must not be so excessive that it would shock the conscience of the average Canadian. For example, the Supreme Court has used Section 12 to strike down certain mandatory minimum sentences, laws that force judges to send people to jail for a long time for relatively minor offenses without looking at the specific facts of the case. Hogg also points out that Section 12 applies to treatment, not just punishment. This means it covers how people are treated in prison, including issues like solitary confinement or the denial of medical care. If the conditions of a jail become so bad that they outrage standards of decency, it is a violation of the Constitution. In 2026, we are seeing a major debate about how we handle repeat offenders versus the rights of those in the system. Some people want tougher sentences, while others argue that the current system is already failing. Chapter 45 reminds us that while the government has the right to punish those who break the law, it does not have the right to be inhumane. Next time, we are moving into Chapter 47 to look at equality rights. This is Section 15, the law that says everyone is equal before and under the law. It is one of the most litigated and debated sections of the entire Charter. Today we are looking at Chapter 47 of the Constitutional Manual. This is the chapter on equality rights, found in Section 15 of the Charter. Section 15 is divided into two parts. The first part says that every individual is equal. This means the law must be applied to you in the same way it is applied to anyone else, regardless of your race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. These are called enumerated grounds. Hogg explains that the courts have also added analogous grounds, things that aren't on the list but are similar, like sexual orientation or marital status. But Hogg points out something very important. Equality doesn't always mean treating everyone exactly the same. Sometimes, treating everyone the same can actually be unfair to people with different needs. This is why we have the second part of Section 15, which allows for affirmative action programs. These are laws or programs designed to help groups that have been disadvantaged in the past. The courts use a two-step test to see if Section 15 has been violated. First, they ask if the law creates a distinction based on a personal characteristic. Second, they ask if that distinction is discriminatory, meaning it imposes a burden or denies a benefit in a way that reinforces a stereotype or social prejudice. In 2026, Section 15 is at the heart of many of our most difficult conversations. It's used to challenge everything from government benefits to the way the police interact with different communities. Understanding Chapter 47 helps us see that the goal of the Charter isn't just to make the law blind, but to make it just. Next time, we are moving into Chapter 55. We are jumping ahead to look at enforcement of rights. This is Section 24, the part of the Charter that tells you what the court can actually do if your rights have been violated. Today we are looking at Chapter 55 of the Constitutional Manual. We have spent many episodes talking about what your rights are. Today, we talk about what happens when those rights are broken. This is the enforcement section, Section 24. Hogg explains that Section 24(1) allows anyone whose rights have been infringed to apply to a court of competent jurisdiction for a remedy. A remedy is a fix. The judge has a huge amount of power here. They can do whatever they consider appropriate and just in the circumstances. This could include stopping a prosecution, ordering the government to pay you money, or forcing the government to change a policy. But the most famous part of this chapter is Section 24(2). This deals with evidence. It says that if the police find evidence, like a weapon, drugs, or a document, but they found it by violating your charter rights, that evidence can be thrown out. Hogg points out that this isn't automatic. The judge has to ask, would including this evidence bring the administration of justice into disrepute? They use a three-part test to balance the seriousness of the police mistake against the public's interest in seeing a crime prosecuted. If the police acted in bad faith or ignored the rules on purpose, the evidence is usually tossed. In 2026, we see this play out in high-profile cases all the time. People often get frustrated when a case is dropped because of a technicality. But Chapter 55 teaches us that these aren't technicalities. They are the only way to make sure the police and the government follow the law. If there is no penalty for breaking the Charter doesn't exist. Next time, we are moving into Chapter 56 to look at Aboriginal rights. We will look at Section 35 and the unique constitutional status of the Indigenous peoples of Canada. Today we are looking at Chapter 56 of the Constitutional Manual. This is a very important shift in our study. We are moving from the Charter of Rights into Section 35 of the Constitution Act, 1982. Hogg explains that Section 35 is different from the Charter because it is not subject to the Section 1 limits or the Section 33 override we talked about earlier. These are existing rights. This means they are rooted in the history and traditions of the Indigenous peoples who lived here before European contact. There are two main types of rights covered here. First are Aboriginal rights, which are activities that are an integral part of a distinctive culture, like the right to hunt or fish for food. Second are treaty rights, which are the specific promises made in agreements between the Crown and Indigenous groups. Hogg points out a key legal concept called the honor of the Crown. Because the Crown, the government, has a special relationship with Indigenous peoples, it must act with integrity. It cannot use sharp dealings or take advantage of technicalities to get out of its obligations. This has led to the duty to consult. In 2026, we see this all the time. If the government wants to build a pipeline, a mine, or a highway on traditional territory, they have a constitutional duty to talk to the affected Indigenous communities and try to accommodate their concerns. Understanding Chapter 56 helps us see that Canada is built on a foundation of agreements and ancient rights that the government cannot simply ignore. These rights are a permanent part of the supreme law of the land. Next time, we are moving into Chapter 57 to look at language rights. We'll see how the Constitution protects English and French and the right to be served in your preferred language. Today we are looking at Chapter 57 of the Constitutional Manual. We're talking about language rights. Canada's bilingualism isn't just a polite tradition, it is a constitutional requirement. Sections 16 to 22 of the Charter establish that English and French are the official languages of Canada for everything under federal jurisdiction. This means you have the right to use either language in Parliament and in any federal court. Hogg explains that this also creates a duty to respond. If you walk into a federal government office, like a Service Canada Centre, and you speak French, The government has a duty to provide services to you in that language, provided there is a significant demand in that area. But one of the most powerful sections is Section 23, Minority Language Educational Rights. This ensures that if you are an English speaker in Quebec or a French speaker in New Brunswick, you have the right to have your children educated in your own language. Hogg points out that this is a remedial right. It was put in place to protect minority language groups from being assimilated into the majority. It ensures that the culture and language of both founding groups stay alive across the entire country. In 2026, language remains a hot-button issue, especially when provincial laws seem to clash with these federal protections. Understanding Chapter 57 helps us see that these rights were a fundamental part of the Great Compromise that made Canada possible in the first place. Next time, we are moving into Chapter 58 to look at remedies for unconstitutional laws. This is Section 52, the Supremacy Clause. This is what happens when a judge decides a law is simply no good and strikes it down. Today we are looking at Chapter 58 of the Constitutional Manual. This chapter is about the ultimate check and balance, Section 52. While the Charter protects individual rights, Section 52 protects the Constitution itself. It says that the Constitution is the boss. If a law passed by a premier or the Prime Minister goes against the Constitution, that law is essentially dead on arrival. Hogg explains that when a judge finds a law is unconstitutional, they have a few different tools in their toolbox to fix it. First is striking down. This is the most common. The judge simply declares the whole law, or a specific part of it, to be invalid. Second is severance. If only one small sentence in a massive bill is unconstitutional, the judge can cut it out and leave the rest of the law standing. Third is reading in. This is more controversial. If a law is unfair because it leaves someone out, the judge can essentially write those people into the law to make it constitutional. Hogg also discusses suspended declarations. Sometimes, if striking a law down would create total chaos, like striking down all traffic laws overnight, the judge will declare the law unconstitutional, but give the government 6 months or a year to go back to the drawing board and fix it before the law actually disappears. In 2026, we see the power of Section 52 every time a major piece of legislation is challenged in court. It is the final word. It ensures that no matter who we elect, they are still under the rule of law. Next time, we are moving into Chapter 59 to look at constitutional facts. We'll see how lawyers actually prove to a judge that a law is doing harm. Today we are looking at Chapter 59 of the Constitutional Manual. This is a fascinating look behind the curtain of a constitutional courtroom. It's about how we prove a law is unconstitutional. Hogg explains that there are 2 types of facts a judge looks at. The first are adjudicative facts. These are the specifics. Who was arrested? What did the police search? These are the facts of the individual case. But the second type is where the real battle happens. Legislative facts. Legislative facts are about the why behind a law. If the government passes a law that limits your freedom of speech, and they claim it's to prevent social harm, the judge will look at reports, statistics, and expert opinions to see if that harm is actually real. Hogg points out that the courts have become much more open to looking at social science and economics to decide if a law is demonstrably justified. This is critical because it means the government can't just pass laws based on a hunch. They need a factual foundation. In 2026, we see this in every major charter challenge. Whether it's evidence about the effectiveness of a particular health measure or the impact of a tax on the economy, the battle of the experts in Chapter 59 is where the fate of our laws is often decided. It's not just about what the law says, it's about what the law does in the real world. Next time, we reach the final chapter of our series, Chapter 60. We are looking at the amendment process, the rules for how we can actually change the Constitution itself. We have reached the final chapter of the Constitutional Manual, Chapter 60. This chapter deals with the proof of constitutional facts. It's fitting that we end here, because looking at the evidence is what we do every day. In a courtroom, the person making the claim has the onus, the responsibility, to prove their case. If we are challenging a law, we have to bring the evidence to show it's unconstitutional. But once we've done that, the burden shifts. If the government wants to use Section 1 to say, yes, we broke a right, but it was for a good reason, the government is the one who has to bring the evidence to prove that reason is valid. Hogg emphasizes that the court doesn't just take the government's word for it. They need cogent and persuasive evidence. This is why we study the law, so we know exactly what kind of evidence the state is required to produce before they can limit our freedoms. We've traveled through 60 chapters of the supreme law of the land. We've seen how this country is built, how power is shared, and how our rights are protected. But the most important lesson is this: the Constitution only works if the citizens know what it says and hold the government to it. Thank you for joining me on this deep dive into Peter Hogg's masterwork. From here, we take this knowledge and apply it to the issues facing us in 2026. Keep looking at the evidence. This is the Canadian Citizens Journal.